I-485 application, that's an adjustment of status application, be approved before an I-360. So I-360 is a petition that is filed along with a green card application many times, and I-360 is used for different types of cases. And one of the most common ones, at least in our firm, is for something like VAWA, which is for victims of abuse, victims who people that are married to U.S. citizens or green card holders, and they're victims of abuse. So that's what I-360 is used most commonly for in our law firm. It can be used for other circumstances as well. So Gautaro, I'm going to assume, since I don't know, I'm going to assume that it's a VAWA application filed concurrently with something with the adjustment of status application, which is a green card application. So the green card application can never be approved. So that's the adjustment of status application. It's never approved without some kind of basis for approval. So there's always a petition, or there's always some kind of basis for you to be sponsored or for you to get a green card, right? So most commonly that's going to be like a petitioner, like that marriage-based, like a spouse, a U.S. citizen or a green card holder spouse. In an I-360 situation, it's a U.S. citizen or green card holder spouse. It is the marriage, and it is the abuse in the marriage that is the basis for you to apply for the second part, your green card application, right? So not everyone's going to qualify to apply for both of these things at the same time, but really the green card application is on the heels of this initial petition for anything with immigration. That adjustment of status application is never filed by itself, right? You can't just file an adjustment of status application and expect to see a green card. It's never filed on its own. There's always something else that is linked to somehow. So that's sometimes a marriage-based petition, I-130, right? Or family-based petition showing the relationship, showing the status of the sponsor. Sometimes it's an employment-based petition. That's an I-140 petition. And the employer shows that they can afford to pay you. The employer shows that you qualify for the position. The employer shows that they've gone through labor certification, right? So that's the I-140 petition. But the second part, that green card application, is still the same. It's the same in family. It's the same in employment. It's the same for humanitarian cases. So I-485 never filed on its own. No way for it to be approved without that underlying basis being approved first. So Gautaro, that's my answer to you. I hope that is helpful. I know it's a little bit more complicated than you probably wanted. You wanted to know. It's not a quick yes. Well, it is a quick yes or no. So no, I-485 never approved before the underlying petition, no matter what that petition is. Okay, there's just no basis for the approval. I hope that helps clarify kind of how immigration thinks about it, kind of how immigration works in the U.S. So hopefully that is helpful to you, Gautaro. If you'd like to have a confidential consultation about your situation, I'm happy to chat with you about it. You can reach us 703-348-1663.